The Firm, India's only show on corporate law, tax and audit matters.
Hello and welcome to The Firm. It's been a crazy busy week. Lok Sabha passed the GST Constitutional Amendment Bill. The government set up yet another tax committee to look into legacy tax matters. And the country's largest law firm, Amarchand Mangaldas, split into two. Now let's get down to what we have for you on the show today. Subramanian Swamy is on a new mission to decriminalize defamation. And the CCI moves to fix the Tesco and the Thomas Cook problems, amongst others. Well, you can love him, you can hate him, but you cannot ignore him. And you definitely cannot ignore the many battles that he's fought. Subramanian Swamy is a former minister, parliamentarian, professor, BJP leader, prolific litigator. And now he's on a mission to decriminalize defamation. Aayush Ailawadi talks to Mr. Swamy about his most recent petition and asks other lawyers if it's a battle worth fighting.
Defamation in India is both a civil and criminal offence. Civil defamation is governed by the law of torts or judge-made law, and the law on criminal defamation is codified in the Indian Penal Code. Section 499 of the Indian Penal Code provides that any person whose reputation has been damaged or was intended to be damaged by the material in question can sue for defamation. Section 500 goes on to prescribe the punishment, which can extend up to jail for 2 years or fine or both. Last year, Subramanian Swamy filed a writ petition with the Supreme Court arguing that the criminal provisions relating to defamation should be struck down entirely. Although under the Constitution of India, defamation is listed as a reasonable restriction to the freedom of speech and expression, Dr. Swamy contends that sections 499 and 500 of the Indian Penal Code are ultra vires of the Constitution.
I found that the concept of criminalization of defamation, which is contained in the Indian Penal Code of 499-500, actually has been grossly misused by people in authority. In fact, you see, when you are as Chief Minister, for example, there is a provision called Section 199, which enables the state to prosecute for defamation. So the person defamed need not even go to court. When they began to be used for even personal defamation, for example, I said Jayalalitha, giving her an administration is like giving a garland of flowers to a monkey. Now, it got nothing to do with her official acts, but she used the public prosecutor to file the case. Now, in the process, this defamation case, criminal defamation case, meant that people tended to or were on the risk of losing their liberty.
Dr. Swamy, the law on criminal defamation might be archaic, it might be antiquated, but it still lists 10 wide exceptions to the rule. Why do you still say that it is unreasonable and disproportionate?
When does those exceptions get invoked? Only after the trial starts. So you have to go through the trial. You have to get arrested and take bail. All that you have to go through. And therefore, these exceptions are no safeguards at all.
It would give rise to ambiguities, wouldn't it, if there is no codified law when it comes to civil cases on defamation?
No harm, but we got large number of cases. Case law is there, and each of them will stand in good stead. I have fought these cases, so I know it's never. In fact, you see, one of the advantages of civil law is that you have something called discovery and interrogatories, where if I know, for instance, if I say that you have been travelling on an illegal passport, I can ask you to give me on affidavit a copy of the passport you used while travelling. In a criminal law, you cannot, because the complainant who claims to be defamed, he cannot be subject to these things. The entire onus is on you. So the civil law is a much more balanced law, and therefore I can access from you documents which will condemn you, or will go against you in a defamation case.
You know, Dr. Swamy, some would argue that in civil defamation cases, it could take years to actually get compensated. And the process, the whole legal process, is incredibly slow. Don't you think that the provisions of the Indian Penal Code are actually the sole necessary deterrent?
I found in my particular case, the civil suits were disposed of much faster than the criminal cases, because there it just goes from adjournment to adjournment, and it is not part of any special court. It's part of a court which takes bail matters, committing crimes, criminals. You literally have to sit with these people and the accused bench and wait for your turn. So I don't agree with this. This can't be an argument.
You say it has a chilling effect on the freedom of speech and expression. So that's essentially Article 19(1)(a). And you also contend that it goes much beyond the reasonable restrictions which are provided in Article 19, Part 2 of the Indian Constitution.
That's right.
You've also given specific examples of countries where decriminalizing this has worked.
Yes.
Do you think the same logic would apply to a country like India?
So, today United States, Britain, Singapore, most of Africa, they have all given up criminal prosecution for defamation. We, in fact, have always followed the jurisprudence precedents of England. England had criminal defamation till 2013. They've just scrapped it. And you have to read the report of the Law Commission, which gave the recommendation which was accepted, that England has suffered in freedom of expression because of this criminalization of defamation. And therefore, I think if they have worked in these countries, even Singapore, which is a very strict country, they don't have criminal defamation, except in when it is collaterally connected to something else. So therefore, I don't see why it can't work in India, where we have a very rich legal tradition.
Anything that stifles one's expression is said to have a chilling effect on free speech. The legal concept of chilling effect originated in the 1950s in First Amendment cases in the US, but has since spread to several jurisdictions around the world. One of the reasons that countries like Sri Lanka and the UK have decriminalized defamation is that these provisions were used to silence dissent or any form of criticism of the government. India is no exception, and these provisions have been misused very often to suppress the media.
At the peak of it, I think we've had 100 defamation cases in 1 year that we were sort of battling with. I think this was in the late 80s. Early 90s.
The attack doesn't come often from the government side. It's the industrial houses. They are more aggressive, and they are, I would say, less tolerant than the government.
Good journalism is about going and talking to everybody who's involved in the story, right? Now, writing a story that is detrimental or damaging to XYZ. You could theoretically go to a court and get a stay order from the story. So, doing good journalism by saying, okay, we're going to give you 24 hours to respond, and you could get a stay against the story that you're going to do, that is definitely a threat.
You will find this kind of cases, they have been lying dormant for years, at times even for decades. They don't come up for hearing. But the purpose is served because such kind of cases, is hang like a democracy sword on a particular reporter. Unless you decriminalize it, as long as the criminality aspect is there, it's a clearly violation of our freedom of expression.
But the criminal lawyers that I spoke to aren't quite in favor of decriminalizing defamation just yet.
India is totally different. The circumstances in which it has been brought into in the US or that UK is going to follow such a law is not necessarily good for our society, because we have no self-discipline. We have no discipline in freedom of speech. We have no discipline in publishing. We have no discipline in talking about people on the electronic media, and we have no discipline in controlling ourselves so as not to damage the reputation of another person.
If you do not have a process which adequately protects reputation, then there's a failure of the system. So defamation is necessary in any such system. Now you go into the question as to whether you need criminal defamation. Historically in India, criminal cases used to move much faster than the civil cases, and as a result, criminal defamation acted as a deterrent to defamatory statements, and was important for protecting reputation. So when we look at it in that context, I still believe that we are at a stage where probably if we can improve the judicial system, criminal defamation should remain as a part of the law books.
When the UK decriminalised defamation, it enacted the Defamation Act 2013 to plug the gap. The Act has clear provisions laid out for journalists, individuals, businesses and website operators as well. India has no anti-defamation law. If criminal provisions or imprisonment are done away with, then victims of defamation can only sue for damages. But there is neither substantial case law, at least not recent orders, nor well laid out principles on damages or awards. Most Indian civil defamation cases are still pending in various courts around the country, and in some recent ones, the compensation demand is 100 crore rupees. Justice Sawant's case against Times Now channel and Dhoni's case against Zee in the Madras High Court both claim 100 crores in damages. Gurudas Kamath filed a case against a Mumbai Daily asking for 50 crores in compensation.
There are a large number of suits pending all over the country. It's one of cases that retired judge of the Supreme Court filed a civil suit in the Pune court and got a decree for 100 crores against Times Now channel. That's a rare case. But apart from that, I don't see anybody getting scared of making defamatory statements in the press, on the electronic media now, and on the TV.
I think the system has to improve. We need to provide for exemplary damages. We need to see how the justice system and the tort law in this country effectively works. The civil process tends to take about 15 to 20 years, by which time the issue of reputation becomes irrelevant. Criminal defamation undoubtedly is also a fairly slow process, but I think it's still a little faster than the civil process.
That's the other big concern, that defamation suits can take over a decade to come to trial, and that defeats the very purpose of the suit, which is to protect the reputation of a person.
Like I told you, my practical experience, the civil remedies, as and when they come up for trial, it would take about 15-20 years for a trial of defamation being completed in the Bombay High Court. Because anybody who claims more than 50 lakhs would land up in the High Court, or a crore of rupees. So most of the people who go to court are those who are going to claim a damage more than a crore of rupees. And in the High Court, I have seen myself that it is taking 15-20 years for a case of defamation being brought to trial. And then thereafter you have appeal proceedings. By the time the person who has been defamed gets justice, I don't think he'll see the light of the day.
When you decriminalize it, I think you need to have extremely strong civil remedies with a fast-track court that's provided to actually protect the reputation of people, which is the underlying object of the defamation law. And until and unless we get to that stage, we should allow criminal defamation to remain on the statute book.
When it comes to free speech, Section 499 and 500 of the Indian Penal Code and the erstwhile Section 66A of the Information Technology Act have one thing in common. Be it online or offline, these sections have been used to muzzle free speech. If Section 66A was struck down by the Apex Court as unconstitutional, then does that mean that the provisions relating to criminal defamation share the same fate? And if yes, then what takes their place in a world dominated by likes, tweets and retweets? Well, until then, I think it's best we think long and hard before we speak, and of course, let Subramanian Swamy have the last word.
Most of the defamation cases I have seen are filed by people in public life, and they just want to silence the other person, so that when you file it, you may not even prosecute it, you may go on taking adjournments. But you will not be able to speak again on this because the matter is pending in the court.
In Mumbai, Aayush Ailawadi.
Well, Mr. Swamy, in this case will be heard by the Supreme Court this summer, so stay tuned. Up next on The Firm, the CCI moves to fix the Tesco and the Thomas Cook problems, amongst others.